I call to order the minutes of the Michigan Board of State Canvassers. All canvassers are present. First item on our agenda is public comment. James Gallant has asked to speak. Mr. Gallant, you have a minute.
Can you hear me now?
Can you hear me?
Yes, I can hear you. Can you hear me?
We
what? You breaking up? Are you on? Am I on?
Mr. Gallant, we can't hear you.
Hello?
Oh, there we go.
Oh, okay. Thank you very much. This is James Gallant, Marquette County Suicide Prevention Coalition. These are my opinions. And Madam Chair, I don't know where you come up with this 1 minute thing. There's in the administrative rules for this committee, for this board, there is the word discretion of the chair does not exist. There's only 5 pages. And I've signed up for every public comment for every agenda item, including this general one. Please do not approve the administrative rules for the recounts that I have on the agenda today, because in the application for that administrative rules, the person who asked for it said they did not provide public comment as required, and they only asked you for your opinion and 4 clerks across the state and didn't get any opinions from anybody, 8 people across the whole state. And then they just rifled us through. I think Jonathan Brader is implementing Marxist-style communism here because you're not following Robert's rules. Like Jonathan Brader, Mike Brady said, the director of legal services. Now, Secretary Benson is doing this exact same thing at the Michigan Independent Citizen Redistricting. Same breach, same problem. Please request the Attorney General opinion, because you were assuming from a 50-year-old Attorney General opinion that wouldn't even talk about Robert's rules.
Thank you, Mr. Gallant. Director Brader will address your concerns about the administrative rules, I'm sure, when we get to that item on the agenda. The next item is consideration of the meeting minutes for the May 23rd, 2024 meeting.
Make a motion that we approve the minutes from the May 31st, 2024 meeting.
All in favor?
Aye.
Motion carries. The next item, consideration of the meeting minutes for the June 3rd, 2024 meeting.
I make a motion that we approve the minutes of the June 3rd, 2024 meeting.
All in favor?
Aye.
Motion carries. The next item on our agenda is report on review of nominating petitions filed for the office of 52nd District Court, 3rd Division, with the Secretary of State for the November 5th, 2024 general election. Director Brader.
Thank you, Chair Growitz. So this situation was created by the fact that a judge retired and a new judge was appointed at a timeline that didn't allow the new judge to file affidavit of candidacy or affidavit of identity in time for the regular deadline for the August ballot. And that resulted essentially in no candidates being able to qualify for August, which meant that there were fewer candidates for the office than offices to be elected, which under the election law means the race goes directly to November. So under that scenario, the deadline to submit petitions is extended, and candidates were given until June 20th to submit at least 500 valid signatures to qualify for the November ballot. So based on that, we did receive submissions. The list you have before you contains the candidates who have filed a nominating petition, which was found to be sufficient under review carried out by staff. And these candidates, again, will be on the November ballot and seeking nomination to the office of the 52nd District Court Judge, 3rd Division. There were 2 individuals who filed nominating petitions, and there were not any challenges filed. So although this did become a non-incumbent position when the affidavit of candidacy was filed, because there is a sitting judge who has qualified based on our review, it will be flipped back to an incumbent position, and Judge Polizzi will receive the incumbency designation. We had a different but somewhat analogous situation that occurred a few years ago. And under the decision Feeney versus Director of Elections, the court's precedent is that the incumbent judge, that it does get designated as an incumbent position with the judge receiving an incumbent designation on the ballot. So based on that, we recommend determining that these petitions are sufficient.
When I see the recommended motion that was prepared, it doesn't address the incumbency issue. Is that something that our motion needs to address?
I think that's the Secretary of State issue. Go ahead, Adam.
We were planning on doing that as the filing official, because the office designation under, I'm blanking on the exact section of law right now under election law, but the designation of the office is to be issued by the Secretary of State. So we were going to do it for that reason.
Peter Rudell has asked to speak. Good morning, Mr. Rudell.
Good morning. I think I can keep it well under 1 minute. We concur with this staff report, and I'm here to answer any questions if there are any.
Thank you for being brief. Do we have a motion?
I can move.
Or do we have? Okay. Go ahead.
I move that we accept the staff recommendation and find the petitions filed with the Secretary of State by the candidates for the office of the 52nd District Court Judge, 3rd Division, sufficient. I further move that the candidates be certified to the Secretary of State for the November 5th, 2024 general election ballot.
Support.
All in favor? Aye. Motion carries. Item number 5. Approval of pending rules on the conduct of election recounts. Director Brader.
Thank you, Chair Gerwitz. So this concerns a rule promulgation about the conduct of recounts under the Michigan election law. There is legislation that has moved through the legislature on the subject of recounts as well. The substance of the rules are very similar to that legislation, but promulgation will allow the rules to catch up with the reality of what we need to do for upcoming elections. We did hold, as required, a rulemaking hearing on this, a public hearing, and the materials you have reflect some of the comments we received during that hearing. It is an open hearing, so anyone's able to attend and submit their input on the proposed rules. So that was pursuant to the Michigan election law. Obviously, we have no control over how many people show up or comment on those rules, but the hearing was held. So what we have before you is basically the rules as proposed after that hearing. Adam, do you have anything you wanted to add substantively to that?
The only other, in addition to the hearing that has to be held under the Administrative Procedures Act, it also has to be open for public comment. In general, for individuals to submit public comment in writing. And it is the rule and the notice of the hearing and the all of the notices and that have to be done in a variety of newspapers, as well as posted on our website and on the Department of Licensing and Regulatory Affairs website. And all of that was done in compliance with the Administrative Procedures Act.
And you did get public comment.
We received one email from Joe Roselle, and in the packet that you have, it has the breakdown of what was the rule, what the public comment, and then whether we accepted. We accepted all of his recommendations and made the changes to the rule accordingly. Nobody attended the hearing. And so the only public comment we received was from Joe Roselle. And like I said, we accepted everything that he provided to us.
Any questions?
I just have one. Where does this put this in the process?
So the next step is to submit it to the Joint Committee on Administrative Rules, JCAR, which is the legislature. So the package that you have is a summary of the posting that we did We have to prepare the JCAR report is what it's called, and it contains the posting for the newspaper postings, the affidavits from the newspaper, the dates of posting and publication and all of that. And as well as the public comment received, the summary of it, the changes that we have made, as well as the rule itself. Similar with every other step of the process, it all gets posted online and then it will be transmitted to JCAR. JCAR from there has a number of different options. They can either waive the remaining session days they have to make a decision. They can introduce legislation on the matter to put the rules into statute, or they can request changes and stuff like that. So that is the next step of the process. With this, we are going to be submitting a letter requesting that JCAR waive the remaining session days that they have whenever that, we'll keep you updated if that happens or whatever JCAR comes back with next. But that's the next step of the process.
Any other questions? Discussion among the board members? Do we have a motion?
I move that the Board of State Canvassers approve the draft administrative rules regarding the conduct of election recounts. I further move that the board authorize the Bureau of Elections to act on its behalf in proceedings through the remainder of the rule promulgation process.
Second.
All in favor? Aye. Motion carries. Item number 6, consideration of procedure rules for the board. Director Brader?
Thank you, Chair Gerbert. So this is also on the subject of rulemaking, but a bit earlier in the process. So this stems in part from the past couple meetings in which the board and staff were trying to determine the best way to grapple with a lot of material that was coming in late the night before, the morning of, or sometimes during the hearing itself, and trying to provide those presenting before the board on both sides of the issue a fair and equal opportunity to present information, not leave important information out, but also allow staff and the board some time to actually review things before considering them in their determinations. So what you have here is a proposed first step in updating the procedural rules for the board. One thing that I think is probably most notable is a provision that members of the public must submit material to the board at least 48 hours before the relevant board meeting, and that the board will not consider material received after the 48-hour deadline. So that would be the proposed language that's in this draft. If the board approves this, we would then go into the rulemaking process, and that is where there would be public hearings that would be posted, and members of the public would have an opportunity to provide comment on that as we go through the administrative rulemaking process. Is there anything you'd like to add, Adam?
Questions?
Just so if there are people, practitioners or whomever in this space that have issues with this, there's still time for them to provide comment and all of that. Okay.
Yes, that would happen during the rulemaking process, ideally. Is that when they would provide that feedback?
And that would not happen before us. It would.
You could certainly, yeah, sorry.
Notice meetings at which to consider these proposed rules.
Yeah, go ahead.
So the first step is when public comment would formally open, it's the same as like with the recount. You could do it via mail. You could submit in like by email to us, or we would notice a public hearing. It is done through like you don't have to be there. It wouldn't be like during a regular board meeting. It would be just a separate public hearing to consider public comment, and anybody can testify, or if they're not able to attend, they can, like I said, send an email and say, these are my concerns, or I like this, whatever the public comment may be.
Ask you a question. Under 168.845, the conduct of public meetings and hearings of the board. And it's just it's maybe an ill-placed question. I don't know. If we go down to the chairperson must do all of the following, item 4. When we have people appear before us who are going to give testimony and they are not attorneys, the chair swears them in. Is that, I don't see that in here that we're taking, that the chair's duty is to take an oath for witnesses. Is that something that should be in the rule?
Go ahead.
I just, before, we've also had the reporter do it. That's the way it was like when I first got on the board, it wasn't the chair did that. We had the reporter do that instead of the chair. I know that Norm would do it because he was an attorney. I never did it because I never felt that was appropriate for me as a non-attorney to swear someone in because I'm not a practicing attorney. So I would always defer to our reporter to do
Who's
that.
also not a practicing
Yeah.
attorney.
So I was like, but like, it wasn't something that I, like, that's how I would do it. That's how I did it. But I
When
don't,
Tony functioned as chair. He would swear in people, take the oath. And Mary Ellen, you've taken the oath.
Sometimes and sometimes not.
Yeah.
I know in judicial proceedings, if somebody is giving an opinion, then I don't think it's necessary to swear them. Swearing a witness is if a witness is actually offering evidence. That's ordinarily the case.
this is where I don't know if that's something that I don't know.
I don't think.
I'm
we
understanding the
don't
difference.
we don't really do evidentiary hearings. The people who appear before us.
Unless it's a recall, because they have to prove what they're talking about for each reason of
That-
recall.
that's
So, I
true.
mean, that's kind of where, but I think but would that also fall under petitions?
Uh,
I'm asking, you brought it up, so I'm asking too. Those, thanks, Richard.
And I did it when I took over for Norm as chair. I did it because that was the practice I had been familiar with. Is there any kind of penalty or anything like that if people, swear to it and then just sit up there and lie? Is it like a court proceeding where they've perjured themselves and then there's some action that can be taken? Because if not, then why do it? Would be.
Good morning.
Morning.
I
Didn't expect this one today, did you?
No, it was not on the agenda. I am looking, I was just scrolling through the Michigan election law, looking for references to oath. There may not be a specific provision dealing with the administration of oaths. I swear I have seen something about this, and I think it might be elsewhere in the administrative rules. Adam, do you have a suggestion of where that might be?
Not off the top.
It was something specifically dealing with hearings conducted before the board, but that's a specific term of art in the context of when this board is acting in its hearing capacity rather than meeting. Which is probably not that helpful to you at this point.
No.
If you wanted to give me about 5 minutes, I could do a quick check and see if I can find anything more concrete to offer to this topic.
I certainly would defer to the Attorney General's office. I think it is, I don't think it is always necessary that everybody who presents before the board takes an oath. I do think that it's generally utilized when people are providing what they claim is factual information or evidentiary information that the board is going to consider as part of a determination it's making. But I can't speak to what penalties would apply if somebody makes a false statement. So in terms of the rules, I don't know that I would recommend, I don't think I would recommend putting in the rules that anybody presenting before the board always has to be sworn in. It may make sense to specify that it can be done or that there might be certain search situations in which it will be done. But I don't know that a blanket requirement is necessary.
What if it was specified that in cases where testimony was being given, because we have had that, we had that when, we had that on a couple of petitions, we've had that on the recalls. And we differentiated between people giving public comment and people who were giving testimony that was relevant to what was being discussed in an authoritative way. And I mean, we've never sworn anyone in, we've never sworn 100% of the people in, but we have sworn people in who are there. We've sworn people in who are there to give a certain level of testimony. Can you word it that way?
Yeah, so Adam is suggesting that perhaps the portion of the proposed updated rule 841 paragraph D, is that what that is? Or whatever it is, something D. That's referring to the processes that are followed during the hearing context, and that is where sworn testimony would most likely be necessary. So that would be one option, although are there any, I guess my question would be, would there be any other context in which the board is meeting outside of that hearing context where people may be giving information that is in the form of evidence or testimony, factual presentations that the board would want to have that additional layer of verification? There might be some additional ones. Yeah, recounts potentially.
I think that Tony's question about, is it necessary? I mean, it can be in there. Does it need to be in there? It is a good one. I think we don't want to make it more complicated than it needs to be, or more extensive. Whether we would ever prefer somebody who we thought was giving false testimony, it seems to me highly unlikely. Or whether testimony under oath before the Board of State Canvassers, would that constitute a violation for which person could be prosecuted? I guess that's it.
Yeah.
The underlying question.
If you don't have it in there, it doesn't preclude you taking that step, does it?
I would not think so. I mean, I would defer to the AG's office on the question of whether, in the absence of it being in a rule, the board can still take oaths. I think they can, but that's really a legal question, I think. The question is, if it's not in the administrative rules, does that preclude the board from taking oaths?
Does it preclude? I'm not sure I can give a good opinion on that sitting here today without having looked at it deeper. In my frantic scurrying through the Michigan election law, I am not able to find specific statutory authority for the board to administer oaths. However, there was also subsequent to the changes to the recall statute, which led to this board taking and making findings of fact, basically to support the reasons for recall, that lent itself to the idea of swearing some witnesses for the purposes of relying on their testimony in this board's determinations. But does that I don't see a statute that says the board can't administer oaths for the reasons that it has done already. If we're going to go beyond that, it's up to the board.
So we have so far had no statutory authority to do it. Or no rulemaking authority.
Explicit statutory authority to administer oaths, no, but there's also nothing in the statute that said that the code that prohibits the board from doing so or acting like a
But in the
administrative body.
rules that we currently have, there's no such grant of authority.
Not presently, no.
And we've done it when we found it necessary. So it would appear to be something that's not required.
It was just a question.
I mean, it's also certainly something that could be discussed as part of the rulemaking process. That would be the kind of change that could be made during rulemaking. But it's definitely something that we can continue to look at as this is going through the process.
You know, not to needle it, but the only question I would leave on the table is, by not having something in there explicitly, does that also mean that in a case where, I mean, we can all recall times here where we've had people come up here that we really truly wanted to express to them our desire to have them tell the truth. By not having it in the rules, does that mean that if the chair decides to stipulate an oath, there's grounds to simply say, no, that doesn't matter here. That doesn't apply. It doesn't really apply here, does it?
Yeah, perhaps. I mean, I think one way of addressing it might be to add in language. I'm not sure this is the best answer, but one way to address it might be to add into the rule that the board may administer oaths as the board determines to be necessary, or the chair.
Does that give you kind of a wild card if you do it at the board's discretion? Does that mean that it makes it a little more difficult to challenge it, or does it, no, that's not the right way for me to phrase that. Does it make it less likely that we would have somebody come out of left field and say, well, you can't require me to swear to that? It seems like there's times when we really, you truly want that. You want the opportunity, you want the ability to do that.
My question is, if even though if we had the ability to do it.
Does it make it legal? Yeah.
Yeah, I mean, I'm not aware at least of an instance in which someone appearing before the board, that it was requested that they take an oath and that they refused to do so, and also insisted on providing testimony. I don't think I can speculate as to what effect putting something in the administrative rules would have on their reacting in that way. Practically speaking, in real time, I'm not sure it would make much of a difference, because they would either do it or they wouldn't. But it may have some effect on, if that were to become a legal dispute down the road, whether it was in the rules. Yeah, go ahead, Adam.
I want to just clarify. I want to clarify one point. So it does say in section 552 of election law and 476, which is the respective sections for hearings on nominating petitions and statewide initiative petitions. It does say that the board has the authority to administer oaths in those two respective sections already, which I believe is the prime, based on the discussion I'm kind of hearing, sounds like the primary times. So I think it would just, I think it would be up to the board and on how rest to proceed, but it is in those two respective sections, excuse me.
It's interesting to think about what would happen if one asked someone to take an oath and he or
And they
she
said no.
refused.
Be a
Would-
pretty good sign that they're not to be taken all that.
Would
Seriously.
we then continue to listen to them, or would we say, okay, whatever, okay, it hasn't happened, it probably won't. It's something that's kind of amusing to consider. Any further discussion? A motion.
I move that the Board of State Canvassers support the amendments to the board's procedural rules. I further move that the board authorize the Bureau of Elections to act on its behalf in proceeding through the rule promulgation process.
Or,
All in favor?
Aye.
Okay, motion carries. Other business? have things they wish to raise?
You gonna give me some more come up a comment or what? I'm supposed to get on every item. I've signed up for every item.
Anything legal ongoing?
There is still open litigation on the Nielsen petition to be a judge of the Court of Appeals. That's on a motion for reconsideration right now. Mr. Woodrow filed a challenge for the denial of his petition for 54th Circuit Court Judge. Our response to that is currently due July 31st. I think that is all that is. No, that's been that. I think that's it. I think that's all you got right now.
And then the Nielsen process, the candidate has lost each step thus far.
The Court of Appeals denied mandamus, and that is currently what they're seeking reconsideration on.
I have a question, Director Britter, on last time we had significant discussions about forgeries and what kind of steps could be taken to investigate reportedly forged signatures. Can you tell us what has been done so far?
We are, I guess I'll defer to Adam, who probably has more detail. I think we're in the process of putting that information together for investigators, but do you have anything you want to add?
No, that's, we're packaging it up to send it.
Sorry, what?
We're packaging it up to send everything to investigators for the full review, similar to like what we did in 22.
So that is information that has been submitted by challengers and information that we ourselves or that you have gathered in your examination of petitions.
Correct. And the sheets themselves as well.
Is there a time frame for doing this?
I-
When do you anticipate that it would be?
I can tell you when we'll get it. I don't know how long it'll take the investigators
No, but can you
specifically.
tell when you will be submitting it to the investigators?
Don't have like a set, but I don't anticipate long. I don't have like a set, like, oh, to say like by today or anything like that, but it's will be sooner rather than later.
Okay, and the investigative agency for this is the state police, am I correct? Or is there some other?
Well, it'd be a common, I mean, so we, at the Department of State, we involve our Office of Investigative Services to help make the referral. But then the actual investigation, I think we send it to the Attorney General's office and then they determine, I guess, as needed, how they need help from the state police.
So we have an Office of Investigative Services in the Department of State.
Yes.
And so that our information would be given to them, and then we would expect that they would further pursue it with the Attorney General.
Yes.
I have one further matter, which I discussed with Mr. Fracassi. And that is with an independent, no, I think any statewide petition is required to have at least 100 signatures from half of the congressional districts. That's 168.509B. And I don't remember ever in our reports in the staff reports, seeing any mention of whether that statutory requirement has been satisfied. And so I asked, and nobody else could remember it either. Am I correct, Ms. Member Bradshaw?
Yeah, I don't ever recall seeing that in the reports.
And nobody could recall anybody raising it, any challengers raising it.
I think the only time that I've ever remember anything, I think was during the hearings when the legislation came in, when they wanted to have a percentage Am I wrong? Remember, they're changing the legislation and they brought in, I believe it was, like, they had to have a percentage of each congressional district for,
Oh, that was PA 608.
yeah,
right?
I think that was the only time that I've ever even heard any conversation, and then obviously that didn't happen at this board, so.
Yeah, I mean, it's not something, it is something that we review. We do a phased review to ensure that there's at least 100 from the required number of congressional districts. Sorry, the required number of congressional districts. It's not something that we mention in the staff reports unless it's an issue, which it has not been. I think mathematically speaking, this is kind of speculation, but it's highly unlikely that a petition is going to have the total number of valid signatures, but not be able to meet that 100 in each of 7 or half of the congressional districts threshold. But if it ever were the case that our review found that they didn't meet that threshold, or if somebody challenged it, whether we agreed or disagreed with the challenge, it's something that would get mentioned in the staff report. In my experience here, which is not as long as some, I don't remember it ever coming up.
So now that we've decided with the statewide petitions to do random sampling, in the report on random sampling, I don't remember that this issue was raised even. So the random sample is used by us to determine whether there's a sufficient number of valid signatures. If there is a sufficient number, does that necessarily suggest that there are that there are 100 valid signatures from, now it's 7 congressional districts, we round up. I talked to Mr. Hauskamp about that because he's better.
When you and I
statistician
talked
than I.
yesterday, from the standpoint of the statistical side of it, the answer would be no. I mean, those are 2 completely unrelated questions. You know, your random sample determines that the universe is okay and has enough signatures and they're all valid. That's one question, and that's answered by the random sample correctly. But the sampling the universe has nothing to do with whether there were 100 valid signatures in Livingston County, or in Oakland County or in Kent County. That's a separate question completely. When we talked yesterday, we talked about that issue where we talked about a court case when we closed out, and you were looking at.
Right, and yes, so a question, and I sent this question by email last evening to Mr. Grill. Does the PA 608 case, which said that the distribution requirement for initiative petitions was unconstitutional, does that have applicability here?
The strict language of the opinion was dealt specifically with that act, which dealt with initiative petitions. Someone could make an argument that there's some analogy to be drawn, but the opinion itself would not make the distribution requirement of signatures for candidates unconstitutional in and of itself.
That opinion I looked at it again, and it relied heavily on the constitutional right of the citizens to propose legislation by initiative or oppose it by referendum. It didn't deal with the right to nominate candidates. Is that how you? I mean,
The most recent pronouncement, I think, from the courts is that there isn't a fundamental right to be a candidate. It's a whole separate rabbit hole we can dive
Right.
down.
And then there's the other case which
There's
based with you, right?
There's the case of Gravelin v. Johnson, which became Gravelin v. Benson, was a case involving an independent candidate for Attorney General. The district court in that case ultimately concluded that, actually I have the language, I'll just pull it up here. There were several statutes that they were challenging in that case, specifically 168-590C2, 168-544F, and 168-590B4. 590B4 is the geographic distribution provision. The district court in that case, U.S. District Judge Victoria Roberts determined that the enforcement of those three statutes in combination against independent candidates was unconstitutional. But in the same order, the court also lowered the signature threshold for statewide candidates to 12,000 signatures. Thus, it's no longer completely clear whether those statutes are being enforced in combination anymore. So it's, I guess, the best I could say is it's unclear at this point.
Could I come at it just a different way for a sec? A dangerous question, right? Question for Director Brader, for Adam. If it ever did become a challenge that was brought up here, if anyone ever got up and said, hey, you know what, we're challenging this because the claim is that there's not 100 signatures in a particular county. It's a two-part question. First of all, it seems to me that they would have to substantiate which county they were talking about. And second of all, if that challenge were made, is it impossible? Would it be reasonable to assume that the Department of Elections at that point could pull records from that county enough to either verify yes, it is, or no, it's not? I mean, this doesn't seem like something that would be hard to check if it ever was challenged.
It would be time consuming potentially, but not hard. So, you know, we do initially do a face review to ensure that there's 100 facially valid signatures from the requisite number of counties. So to the previous point about does random sampling capture that aspect? No, random sampling is about the total number of valid in the entire petitions. And the way that we enforce the 100 requirement is to make sure there's at least 100 facially valid, and then have the opportunity for challenges if people want to dig in the entire petition and say there's not at least 100 from required number of districts. If they did that, they would need to, yeah, as you said, substantiate that, you know, we've looked at this and there are not 100 from X number of districts. And there'd be a number of ways, I guess, of going about that. You could go by congressional district, or you could do it by process of elimination. Most counties are entirely within one congressional district, so it wouldn't be that difficult to determine and sort out just by the petition sheet which congressional district the signatures are in. For those congressional districts that do cross county lines, most of them even then are, you know, they don't cross municipal lines. So that would be a further way to subdivide it. And then for cases where municipal lines are crossed, like in, you know, Detroit, for example, we can still do it using qualified voter file and looking up the individual record and determining what congressional district the voter is in. So we would need a challenge that's actually articulating the basis on which they don't think that requirement has been met. But if we got that, we could certainly check it and verify it either way.
So, for clarification, the requirement is 100 the signatures from half the congressional district.
Correct.
It's not county related, although you have to look at the counties in order, because the petitions are countywide petitions, right? So you're putting together two different things.
Yeah, and we also have the municipality line that's written on each individual line. So if it's entirely within one county, that makes it easier because we just need to look at the county line on the petition sheet. But the next level of complexity, which would take longer, but not an enormous amount of time, would be looking at the municipality on each line. And then only in those cases where a congressional district crosses through a municipality would we need to look it up individually in qualified voter file to determine what congressional district the voter is in.
So we could let it go, and if it's not broke, don't fix it, right? And if somebody does do a challenge, then we fix it then. Is that what I hear you saying? There's nothing
That's
really.
my opinion, yes.
I try to give you a lot of wiggle room there, you know,
Although I think it would be helpful to have in the staff report that requirement has been satisfied. Because in that circumstance, then a challenger would have the opportunity. I mean, they would have the incentive, I suppose, to object to the staff report if they think that it was not accurate with regard to the distribution requirement.
Yeah, we can certainly look at that. and explain the process in the staff report.
Has anybody ever failed? Has it ever even been raised in? I mean, we don't have a whole long institutional memory here, but I don't remember anybody raising it with any of the candidate petitions, and I don't remember any discussion of it when we were talking about random sampling. And Vice Chair Hauskamp and I met with practitioners. Nobody thought that this was an issue. So I think it's kind of an intriguing issue, but perhaps one that we don't, that we can address should the need arise.
Yeah, and I mean, so I don't think it's come up a lot, and this is not a statistical argument, and it's absolutely correct that the random sampling doesn't account for that issue. But practically speaking, when you have a statewide campaign, unless your canvassing effort is extremely focused geographically in one part of the state, it's going to be unlikely that you can get the total number of ballot signatures that you need statewide without also satisfying the congressional district requirement. You'd really have to be in a pretty small area. If you're doing it in one corner of the state, it's possible. But if you have any kind of statewide operation, it's going to be pretty hard to get above the threshold without also hitting that 100 per half of the congressional district requirement.
Member Daunt, you're thinking
I'm very truly, I'm thinking, what in the world were you doing otherwise, or whoever's idea this was thought of this even, because it's just not something that has come to, it's, I mean, now that I'm thinking about it, I'm like, yeah, it hasn't come up. It's always, I guess, kind of in my mind been an assumption that if you are a statewide candidate, you've got people in different corners doing this. And so, and campaigns I'm aware of and things I've worked on in the past, you sort and look through and make sure you have that before you submit. Kind of one of those basic things. But as we've seen over the last few years, some of these basic common sense things aren't necessarily being followed by all of the candidates out there. Or not necessarily candidates, but the people that they've hired.
We've certainly seen that, I think. And that's why I said, I think it's unlikely that you are going to have enough ballot signatures statewide, but also not meet this requirement. Because if you're not going to, the types of petition submissions that we've seen that I think wouldn't account for this are also the ones that have had other issues that have knocked them off. So you'd have to thread a pretty narrow needle there, whatever, pull, whatever, thread the needle. You'd have to be in a pretty unique situation where your canvassing and your campaign was organized enough to get the total number of valid ones that you needed, but also not organized enough to have any kind of statewide operation and get them from different parts of the state, which of course is possible. I don't think it's likely, and I don't think we've seen it raised.
It is not a particularly burdensome requirement. It's certainly less burdensome than and less complex than the requirement that was proposed by PA 608 and dealt with by the Michigan Supreme Court. So, well, this has been instructive. Do we have any further discussion on that issue?
I have so I don't have anything on that issue. I have a couple of questions on a different issue, if we're ready to move on. I wanted to bring up a couple as the board knows, we've been working with the legislature on the petition package, the bill package. So I wanted to bring up a couple of questions just to kind of see and have a little bit of discussion on them. So the package did pass, I think last time we met, it did pass the House at this point, so it is going to the Senate, and there obviously will be more questions probably and more discussion once the Senate comes back from recess. But a couple of the questions that have come up, there's 3 points that I wanted to just talk about briefly. So the first one deals with constitutional amendments and the requirement for the alter and abrogation piece of it. The statute currently requires that on the back of the petition, you reprint in full the provisions of the Constitution that are altered or abrogated. One of the proposals that's already in the bill right now would basically be to call that a form requirement, which it is a form requirement, and to put that up front with the approval as to form process and say challenges approval as to form, et cetera. And once we go through the approval as to form process, if the board approves the form, that insulates going forward. But a question has come up as to the republication piece of it and whether or not, and just the board's thoughts on it. And when I'm saying the republication piece, the back of the petition, if you're doing a constitutional amendment, would still have a bold strike through, like this is what's changing. It still would have all of those requirements. But it's that second part where you have to reprint everything in full as it exists in the Constitution now. So that's the question. If there's any thoughts basically on eliminating that requirement or modifying it, or if the idea of just putting it in upfront approval as to form, giving the safe harbor is a good solution. And if I didn't explain that well enough, please let me know. I'd be happy to try again.
Suggesting that there is consideration of removing the requirement, eliminating the alter and abrogation requirement altogether.
Not eliminating the requirement altogether, only eliminating the requirement that you republish the Constitution in full. So the back of the petition would still have, so let's say I want to amend Article 1, Section 1. I don't even know what Article 1, Section 1 is off the top of my head, but let's say I want to amend that and remove the word the. I still would do a bold strike through removing the word the, but I wouldn't then underneath it have to reprint Article 1, Section 1 again, exactly as it exists now.
Given that context, I do not like that idea.
I'd rather have someone looking at it and seeing like, this is what it was, this is what we're doing. I don't know, it's always my adage, so I'd rather be looking at it than looking for it, because I know people aren't going to pull out their phone and pull out the Constitution of the state of Michigan and try and figure out what you're talking about, because they're walking out of a grocery store, or they're walking out of a ball game, or wherever they are. I'd rather have it all printed.
Not that they'll read it, but.
True, but it's there.
Right, no, I agree with you. I think it should be there, but I think there was an additional question about whether that should be considered form, which we would then consider in advance.
That's how the bill is written now, is that would be done during the approval as to form process, meaning the challenges would be raised in the approval as to form discussion. And if the board approves the form as is, that's a safe harbor. Again, presuming that nothing changes on the petition sheet. But if a sponsor comes to you and presents it, it's reprinted, and the board says, yep, form looks good, then they go circulate and they can rely on the board's approval.
So would that kind of count for that raise the wage, where when we looked at it, it had a certain number. I'm just saying, like, no one looked at the back, because honestly, when we're doing form, we're not, in our statement, we say that we are not responsible for the printing on the back. If I know I've said it a lot, I just can't recall it offhand. Are you stating now that the change that they want to make is that now that's part of the form?
So no, the board would still not be approving the content of a petition. That would not change. What the board's approval as to form process would essentially be the exact same as the board's approval as to form process is now. The difference is it would be kind of merging it like the summary language process on a petition. The idea that once you approve it, it insulates from future challenges if the board's approval occurs. Absent something changing. So like with the raise the wage, the petition was submitted was different than what was approval as to form.
So
That's not,
I'll ask more direct. Would this change have saved raise the wage on their mess up?
I don't think so, because the version that was approved as to form was not what was submitted.
Can you give me an example of, if this existed today and someone came before us with a constitutional amendment? And we kind of blessed it all as part of the form. Give me an example of how that would impact when they came back.
So I wanted Article 1, Section 1. I want to amend it. I come to the board and provide my, I request approval as to form, request summary language, board approves it. I have on the back, these are the bold strike through with the constitutional amendment I want to make. I've reprinted it. The board says, yep, great, go. I gather my signatures. I submit signatures. When we are doing that second meeting and considering the validity of the signatures and whether it's sufficient, we are only considering the validity of the signatures and whether it's sufficient. We're not going back to rediscuss, is the summary language accurate or misleading? Is the form missing something or any of that? That has to be done up front as the approval as to form process and the approval as to summary process. So that way, when I go through that work up front to get approval as to form and approval for the summary, the board agrees, we have all of that discussion, I can rely on that to circulate my petitions. Now, if I'm circulating, I get my approval as to form, I get approval as to summary, I start circulating, but then I decide, oh, I want to also amend Section 2. I have to start over.
Okay.
Or if I don't start over, it's still an optional process, then we are not protected. I, as the circulator and sponsor, am not insulated from future challenge because I've circulated a petition that has not been approved by the board.
So if there were a case where you came in with a constitutional amendment, right, or if you were proposing that and we approved it, and it came out that when you came back in front of it, it came out that there were 3 sections of the Constitution that were now impacted that either simply someone didn't know about or someone maliciously or deliberately tried to cover up. I'm thinking back to when we had a fairly animated discussion about Prop 2, and we actually deadlocked on it because a couple of us said, there's things in the Constitution that are being impacted based on the arguments of the attorneys. This doesn't. Does this silence those discussions when it comes back?
During the signature canvas, so the second time, yes, those discussions would be moved to the approval as to form step.
So
You do it at that point.
that would then require us to determine whether they have sufficiently set forth all of the altered and abrogated provisions.
But
I
we're not
don't
allowed to
think-
do the content.
Yeah, it wouldn't
Confused.
change because the Supreme Court has been clear on what the board's role is with the extent of alter or abrogate. So it wouldn't change the board's responsibility with that. The biggest change would be basically just the timing of when the board is considering it and saying that all of that discussion should happen before people start circulating. And that if we come to the board and the board says, yes, go ahead, that sponsors can rely on that.
It sounds like it's meant to address a situation where a challenger might be like, oh, they don't have something in here. But I'm gonna sit on it until they've submitted, and then we're gonna bounce them. Gotcha, yeah.
Gotcha.
Which is entertaining, creates for lively meetings. But yeah, I definitely, the alter and abrogate like that, I think we're all pretty on the same page that no minimizing of what that requirement is. I guess I'm agnostic on whether or not it's part of the form phase. And I would imagine the practitioners are probably agnostic on what side of the proponent versus challenger they're on.
We've also said that sometimes it's easier to address the issue and get the answer to the issues that come before us, knowing what all the rules are beforehand, so that we don't have that kind of gotcha moment. And so I think this is where the legislature is probably asking us possibly of where we would stand. Do we want to say that abrogate and alter should be under the form conversation so that we don't have the gotcha moment and sitting here and watching citizens and registered voters who have signed petitions, who have sat in these meetings with us, who have never been in these meetings, but like knowing that I just did everything that I could. Someone just said gotcha, and now my signature no longer counts. So I think it is up to us to decide, instead of passing it, I think it is up to us to decide, should this conversation be had under form? And I think that that's what they're proposing. Instead of allowing it to go through, have signatures, and then come back and say, no. I've sat here long enough. If you have it and it's laid out of where these conversations need to be had, I think that it opens it up for a better conversation to people. One, where we want it all printed out. I think we're all here. But I think it is up to us to give our opinion as the board that comes to the legislature, that we do want people who petition the state for their signatures to actually count, instead of being under whatever practitioner finds whatever after the fact.
And given Adam's answer on just using the raise the wage issue, as long as I would feel more comfortable if there's clarity, language in some fashion that type of change is significant. That's not just oh, well, okay, you already approved to form, so, we can cross out, 2 or I can't remember exactly what it was, if they added a 2 or crossed out a 2.
There was a cross, there was a thing, right? So, but that question for me, and I absolutely agree with you, is that there has to be clear, it has to be clear to that. But I think it would stop those kind of things to happen. And I think that everyone knowing what the rule is beforehand and what is going to be discussed beforehand, I think would give a little bit more. My word is not coming up to me, but I think it would give someone, a registered voter who gets pushed petition or is working on a campaign, I think a little more assurance that what they're doing it's meaningful, and it's gonna something. Look, if you didn't get the signatures, you didn't get the signatures, but if you got the signatures, someone's not going to say, aha,
Yeah.
like they forgot the period over here and now they're all gone.
Having been part of groups and efforts that brought things to the board before I was on it, there was always that knot in your stomach of like, oh, what's Mark gonna find on this that he's gonna try to make an issue of? And so I understand that.
Yeah, I think just like having, but I think that there needs to be some clarity on that, so if the petition that is circulated has font size that meets all the requirements, but something weird happened in the printer, but what we approved is there, those items. I mean, they all come in from everyone has something, whether, I do remember when we started talking about marijuana, legalizing marijuana, like we've had a petition that was, the font size was so darn small that we couldn't read it. but they got everything that they needed, but they didn't want to go to 2 pages. So they got everything on 1 page. And that's what I'm saying is there has to be some clarification of like, that conversation needs to be at here, but understand that that is what whatever you have submitted to us, that is what has to go to the people.
So
Am I
there would be explicit safe harbor language, as there is now with the petition summary. But, you know, I think with the petition summary, I mean, we spent a lot of time approving, you know, getting to language on a recent petition, which we could agree upon, which everyone could agree upon. And then they circulate with different language. Is that, but the safe harbor language says that they have to use the language. I just think some of these requirements, I mean, that safe harbor language with regard to the summary says that if we approve a summary, that's what they have to use. What happens if they don't?
Well, it says that if you approve language and they use that language, then you cannot entertain an argument at a later date that the summary was misleading. They don't have to use it, but they should. But it also creates an issue if they use the same language, but then the actual, what was on the back of the petition has changed, which I think was part of the issue. And well, which one was that? That was raise the wage. So I don't think this would be changing this, as I understand it, the summary language. It would be more about putting, changing a little bit what actually has to go on the back.
Yeah, and it would be putting that together. And I do think some of the concerns, like member Daunt, that you've raised about, and member Bradshaw about like the clarity would still, they are in there to say like, if you go through this process and you take exactly what the board approved and you circulate exactly what the board approved, then you're insulated from a future challenge as to the form and summary requirements. But if you change something, you can still circulate. Approval is to form and approval is to summary is an optional process. You can circulate if you want, but if you don't go through the approval is to form / summary process, or if you change something after that, then the challenge can be raised at any point still.
I have a concern just one concern, and member Bradshaw, you touched on that concern. So we've all seen, just in my short time, people who will get a form approved. They will go off and something totally different or something substantially but subtly different ends up on the petition that the signatures are gathered on. And then they come back here and the excuse is, well, you know, that was a printer error. Or we sent it out to the printer and they got rid of all the spaces, but they really didn't. There really is a space there. You just have to have a microscope to see it. Or in the case of raise the wage, where a 2 became 1 or a 1 became 2 and the strikeout ended up, what was really cast out was 21 and it was materially different. And the courts, you know, went that way. I wouldn't want this board to have its hands tied, so that if we had a form that was approved and someone came back and that form had been altered, whether it was a printer error, whether it was a deliberate, subtle change, I wouldn't want us to have our hands tied to be able to say, even though there's 100,000 signatures, this doesn't meet.
I don't think as the language is written now that the board would be. In that instance, the only time that a challenge would not be allowed to be considered again in the future would be the exact same situation that we have now with summary language, where you get the summary language approved, you put it on the petition, you circulate, you don't change anything on the petition. And then when you submit, you can't have another discussion of, is this misleading? Because that was approved by the board and already flushed out. So it would essentially be that same piece, that if I come before you with my Article 1, Section 1 constitutional amendment, I list everything I'm required to, I get my summary, I get my form, and I just take that and it's made and I circulate and submit, then I'm insulated. I'm protected. because I
As
went
long as
through all
that's
that work.
exactly what you present to the voter and all the way down to things like spaces and strikeouts and numbers and whatever else might be there.
I think this kind of really hits to my objection of approval to form conditional approval to forms. That's why I don't do conditional approval to forms, because I want to be looking at it. And I would have to say that the question I would have is if you had a constitutional amendment committee that piecemealed. So they came to us for approval to form, they came to us for the summary, they used our summary. And then I'm assuming that this would be the protection. So if we approved, this petition, how it was given, and then they used a different font or something when they printed it, that challenge can go through because what we had approved was what was put in front of us at the time. And so if there was any kind of printer change,
That
or
still
error,
qualifies as a
it would
legitimate.
still be challengeable because that wasn't the form that was in front of us that we approved. So am I,
Yes, and it's a
Okay.
different question as to whether or not you would reject later, right? I mean, depending on what it is, but it's at that point, the exact scenario you gave, yes, like you could raise that because it has been different. Whether or not that affects anything, may not be an issue substantively. Like if you just switch from one font size to the other, but everything's still fine, that may not, you all may decide that's not an issue. But I, as a challenger, wouldn't be foreclosed from bringing that argument because it's different than what the board approved.
That would be that, again, that's the only concern I have is that we find our hands tied and then we've opened up a door for, the dog ate my homework argument gets used every single time. Because we've seen that.
I think it's meant to limit it only to that very narrow instance.
Up here, for the simple reason that these are really intelligent people with lots and lots and lots of horsepower. When they come in here and they're basically saying to us, we never took the time to run a print press before we ran 100,000 copies of this petition. That is, to me, it keeps coming back as a very disingenuous argument. And so I want to make sure we're not closing the door for being able to say, hey, wait a minute, you materially changed something.
Well, and hopefully it would encourage some more proofing as well in that by kind of giving that insulation as well. Because if you're giving sponsors that insulation now, then it kind of does put a little bit of the burden on them to just double check and triple check and quadruple check and make sure, we give everything. And the bill package also requires us now to create a template. We make available for statewide sponsors. We will create that template, double check to make sure that it's the same and run it and make sure it's exactly the same that was approved. So hopefully that would also have an incentive for that as well, that by giving that safe harbor.
With the Axe My Tax petition, we didn't approve it as to form because member Dawn pointed out that there were typos.
They withdrew it. Remember? They were gonna go fix
After
it.
we
After we-
reject them a couple times because they couldn't get it right.
3 times, as a matter of fact.
I mean,
But that, that went to the fact that there were these errors.
Right.
Was cause for now.
That's an interesting question. So let me ask you a theoretical question. So if we had approved it with the typos in there and they've gone out and corrected the typos in the final and it was proper English, would we then reject it because it was done properly?
Only you would ask that question.
I probably.
what in the hell are you saying?
Well, but again, this process is optional.
It is, yeah.
The answer, by the way, is just don't run spell check after you come to see us.
Or have the mystery L's, though.
Yes.
That was fun too.
So I think I'm gonna want to reiterate just to make sure I'm not misstating anything. So if I'm wrong, so it seems like that you all unanimously agree the republication requirement that's in statute needs to stay. And that you're okay with with having that be in the approval as to form process, and that discussion kind of moving it up front, putting the safe harbor in, so long as we're not basically foreclosing the board, that if something changes after circulation, then you lose the safe harbor. Or let me rephrase, I'm sorry, if something changes after approval is to form, you lose the safe harbor. Is that a fair summary?
Okay.
I have two other law. The second question is surrounding the 180 days piece. There's a requirement in statute that says signatures have to be gathered within 180 days of filing. So when the petitions are filed, we look back 180 days. And the signatures have to be valid within there. There's been a question as to whether or not that should be extended in some way and whether the board is interested in bumping that up to like an insert number.
What was the statute before it became mandatory for 180 days?
It was a rebuttable presumption, meaning that we would look back 180 days and anything outside of the 180 days, there was rebuttably presumed to be invalid, but that there was a board procedure adopted, I don't know if you know, I want to say in the 70s, maybe 80s. I don't remember the exact date, but there was a board procedure that basically said in order to rebut the presumption, the individual voter has to sign an affidavit and submit it. And then in approximately 2016, give or take a year, the statute was changed to just be a flat out 180 days. Anything before is invalid, period.
So basically codified what practice was, but streamlined it.
And so now the question is 180 days too short? And partly because with turnout increasing, the minimums increase. So that's the question is, should that 180 also increase at all?
What would it increase to?
There's no proposal for a number, so I think that's kind of the question. I think the majority of states that have petitions have some time frame in it, ranging from 180 to like 400 days. But that's also coupled with a different filing deadline than what Michigan has. We have a very tight filing deadline from when we have the filing deadline to certification, in that it's less than 60 days. Some of the other states that say you can circulate petitions for 400 days, their filing deadline is a year before the election. So it varies in all aspects. So I don't have a set number. I think the question is just, is that even something that the board is interested in adjusting in any way?
Does the tight period, does that affect your process? Does the 180-day limitation, is that important for you because of the short filing? Because as I understand it, the longer the period during which signatures can be obtained, the more likely it is that people move, and it's harder to verify the signature. If you had and your time to verify signatures is limited. So maybe you need 180 days. The circulator might prefer more, but is it a matter that you would weigh in on, just in terms of what the best thing is for bureau and board processing of petitions? Is the 180 days important to you and then to us?
I think the longer it is, the higher percentage of signatures submitted will require a more in-depth review to determine if they were registered at the time they signed it. It's always an issue to some extent because of passage of time, but theoretically, the longer you make that 180 days, you would assume there'll be a higher percentage of signatures that we would need to spend more time on validating. I don't know that I could really give, and maybe Adam could, but I don't think I could give a reliable estimate on how much time it would add for us to, you know, if you said 360 days or 270 days compared to 180, but lengthening that period would somewhat increase the amount of time we spent on those more complicated ones where the voters' status at the time we're looking at it is different from what it was when they signed the petition. The flip side is, I suppose, if you're rejecting fewer signatures because the durational time is longer, then that might save us some time because we're not rejecting as many, but that's hard to quantify. Adam, do you have any?
The only, I agree with everything that Director Brader said. The only other concern that I would have is the longer you make it as well, the risk that we're gonna get more signatures filed, which is more work in other steps of the process.
And
I'm-
when you say more, you just mean a greater X.
Greater
Yes.
number.
So I'm thinking like Prop 2 and Prop 3 that submitted, the two of those alone submitted over 1.5 million signatures in 2 drives. If there's more time to gather, then the cushion that's going to be submitted is going to be greater, which adds processing time as well. So that's kind of the both sides of it.
My instinct is this is a solution in search of a problem, and I don't think it's necessary.
Well, and we also live in we live in a very mobile society. So when you start talking, I mean, even just hypothetically, 400 days, if I were collecting signatures at a rest home, I could tell you the number of signatures that are invalid are going up. If they were challenged, but that's not a bad argument. The argument is that a lot of people are moving. There's a lot more motion in 400 days than there is in 180.
And that, I mean, that in defense of the statute, that is the purpose of the statute.
Right.
That it to ensure that just the processing and the modicum of support for a statewide drive is there. So.
The other thing I would just note is the 180-day cutoff was that was one of the main issues in the Graziano multi-year litigation saga. The court, and so one of the things they were trying to, please correct me if I'm saying wrong here, Eric, but they were trying to challenge the constitutionality of that 180-day limit, but the courts never got to that question because there were other issues that disposed of the case. So theoretically, this could be something that was challenged in court again, but that's hard to say.
So would that challenge be this? Would they theoretically challenge it if it was 270 days or 185 or 400? I mean,
Yes.
Probably, yeah.
I think Ben on both.
So is it fair to say that you all think it's okay as is?
to leave it 180.
Yes.
I'm
I
good
endorse
with
that,
it.
yes.
Yeah.
I just want to make sure and then the last is not a specific, but it's just more of a general question that's been raised. So we've had a lot of discussion on the initiative side. Because that's obviously what was put forth before, but now questions have been raised as to whether or not some of the form things that have been done and some of the standards that have just been put in into statute should be replicated in the candidate side as well. And I'm thinking mainly in 544C, whether there's interest in kind of streamlining some of 544C. And I'm going to pull up real quick. Mainly some of the requirement, and my internet doesn't want to work, so I guess I'm not going to pull that up. But it's mainly some of the board's procedure requirements under 544C, which are the I'm going to loosely call it the like investigation piece of it. If you recall in 2022, these were some of those provisions that say things like the board is allowed to look at the face of the petition. The board can make these determinations without comparing it to QDF, things like that. There's not a recommendation to change any of that, but whether it's worth it to kind of streamline some of that language and just make it clearer as to what exactly those sections mean. I'm thinking of 544C. I think it's 11 and 12. Maybe it's 10 and 11, but it's some of those later ones that we had a lot of discussion. Thanks, Jimmy. I was right. It was 11 and 12. I am looking back because I'll save my anecdote for later. So in 11 and 12, it's after the hearing of the canvas, the board is authorized to do these steps, and the board under 12 there's penalties under 12 and things like that. So it's just a question of, is the board interested in just clarifying what some of those sections mean? We had a lot of this discussion in 22 as to what some of this language was and what the board's role is. Specifically, what is the board's role to quote unquote investigate? What is the board's role in to conduct a quote unquote hearing? One of the penalties is to ban people from circulating. So just kind of clarifying what some of that is.
It's hard for me without looking at the language.
I'd rather, I don't want to, I'd rather see it.
Completely fine. Okay.
I'd rather see it printed in front of me.
I was gonna say, I think that if everybody else is like me, gonna work better with seeing what it is, what's the proposal, what's the reasoning.
That makes sense. I don't have like specific changes. It was just kind of like, is that even like something you're interested? So it seems like at least interested in considering like a proposal. Is that?
I wouldn't want to make the assumption that the board didn't have an opinion or a
Right.
thought on it. But if we don't have that in front of us,
Yeah. Okay.
at least that's me.
That's kind of what I assumed. I figured that you guys would want like,
Do we have enough time window that if you had a specific recommendation or they had a specific, we don't have to decide that today and
yeah, no, you don't need to decide this today. So the Senate's not going to come back into session and really start hearings on this probably until September is my guess. That's when they come back into session. So there will definitely be time to consider this.
This arose in connection with our obligation to investigate forgeries, right?
Yes, and just in general, yes.
And right, what if we suspected forgery, what did we have
Yeah.
to do? Did we, as was argued by some of the candidates, did we then have to examine every signature and compare it to the QBI?
Yeah.
Right, and that was decided.
Well, and some of that was why we did the sampling process as well for some
Right,
of
right,
these too.
but also the Supreme, there were challenges obviously to the procedure which we did adopt. And those challenges were resolved in our favor, but what we had done, and that was relying, as I recall, on the language in 544C. But yeah, I mean, I think it is important to clarify what our obligation is.
So what I will say, if this sounds as well as sounds correct as well, is that you're open to the discussion, want to see specifics, and yes. Okay, I figured that was the case, but I figured I had you here and I would ask while you guys were here. So I will keep you updated as things come. Like I said, there will be a hearing. So if you guys are interested in going as well, like you did in the House, certainly would welcome that as well. And I'll keep you updated whenever we know more.
And then if you can let us know specifically what kind of language that.
Yep, I will.
do you believe our aggregate appearance at the House, did that help things or was there a positive impact on the outcome by us appearing in front of the House sub?
I personally do think there was a positive impact. And I think the biggest benefit is because this is a bill that is largely being driven by y'all. And the questions every single time that I always heard in any of the hearings at the House were, what does the board think about this? On both sides, several representatives, whenever anybody was coming up and saying, what is, I want this proposal, it was always, how does the board feel about that? So I do think it is helpful for even that. This is, I'm very happy about this bill. I'm very happy with where it's at and the work that we collectively as as a group have put into this, and that includes all of your guys' time and review as well. When I say we, this has been a lot of work and makes clear changes. Just makes clear the requirements for everybody, which is important. And I think that having the four of you there to kind of emphasize that point was helpful.
Well, if we can help you do the same thing with the Senate, I can't speak for my colleagues, but let me know. We'll be there.
Certainly will. Oh, yes. Thank you.
If we're done with this.
Yeah, I'm good with that. That was what I had. So we did get two petitions in for no party affiliation candidates running for president and one running for a state representative. So we'll have those at the August meeting. In looking back through the motion in August, I think that we are covered. In August, as you'll recall, we extended the filing deadline to be for challenges to be 7 days following the release of the sample or the challenge deadline, whichever was later. So I think that we're covered with that as well. But I would recommend the same thing. If you want to make a motion, I think we can, but I think that the procedures kind of laid out your approval, for lack of better terms, on that is laid out already. But that's the update that I had for those petitions as well.
So I heard just listening to the radio the other day, I can't remember which Sirius channel it was. And they talked about some news story of some guy who legally changed his name to literally anybody else so that he could run for president. Is this one of the folks who have filed?
He did not file for independent for president. Oh, and I'm sorry, actually, we received 3 filings. One did not submit a sufficient number. They submitted 1,000 signatures to run for president. And the minimum is 12,000 in this instance. So
The other two did submit 12.
the other 2 submitted at least 12,000, yes.
Wait, there are 2 other independent candidates for president?
Yes.
Okay, I thought you
Yep.
said that one was for a different.
Yeah, I'm sorry, I misspoke. So there's 3 total that filed for president. One did not submit a sufficient number. One submitted 1,000 signatures. The other 2 submitted at least the minimum. And then there's a 4th one that filed for state representative as a no party. I forgot about the other one, the one that came in by mail.
And those will come before us in August.
Correct.
Anything else? Anything further coming before the board and adjourn.